So good morning, afternoon, everyone. This is Nina Olson. I'm the Executive Director of the Center for Taxpayer Rights, and I just want to thank everyone for being here for this very important conference that we've been trying to do for 2 years now. This conference was originally planned to be held in Pretoria, South Africa, at the University of Pretoria, the African Tax Institute, our host, in October 2020, and COVID intervened. We hoped that we would be able to be in South Africa this October, but again, COVID made it not possible. And the planning committee made the decision that we should go ahead online because the issues are, in fact, with the coronavirus, more important than ever. What is the role of taxpayer rights as human rights, and what do they play in that capacity as human rights in developing countries? But to me, the issue of whether you're a developed or developing country is kind of a misnomer. I've spent a lot of time going around the world studying tax administrations, when I was the National Taxpayer Advocate, and since then, and in many instances, where I see with taxpayer service or goals or thinking, thoughtfulness, the developing countries are often very far ahead from the developed countries because the developed countries take so much for granted in their administrations and their bureaucracies. So I think that we have all a lot to learn from this conference. I want to say a few thank yous first. I obviously want to thank our planning committee, Chris Evans from University of New South Wales, Real Frans from University of Pretoria, Annette Agutu, who's from the University of Pretoria, Karika Fritz from the University of Witwatersrand, and Pasquale Pistoni from IBFD. And our host virtually is the African Tax Institute at the University of Pretoria. IBFD, the International Bureau of Fiscal Documentation, is our technical advisor. And we have a number of sponsors that I want to thank: the American College of Tax Counsel, tax analysts, the South African Institute of Chartered Accountants, and the International Fiscal Association of USA. They've all been very supportive of our work here, and that has also enabled us to keep the registration fees as low as we really can, and also open the conference up to students at a fairly reduced rate. And that's very important to us because the next generation of scholars or practitioners or government officials is key to bringing about taxpayer rights and human rights realized. So now I'm going to turn it over to Annette Agutu, who will welcome us from the African Tax Institute.
Nina, for those introductory remarks, and hello everybody. On behalf of the University of Pretoria's African Tax Institute, the Department of Taxation, and the Center for Human Rights, we are pleased to welcome you to this prestigious event. The University of Pretoria is the largest residential university in South Africa and consistently one of the top 10 universities in Africa and one of the top 500 universities globally. We are very proud to be a co-host of this conference, and we want to thank Nina Olson and her team for bestowing this honor on the African Tax Institute, which we normally refer to as the ATI, to host the 6th International Conference on Taxpayer Rights with the theme Taxpayer Rights, Human Rights, and Issues for Developing Countries. The ATI was formally established in the Faculty of Economic and Management Sciences at the University of Pretoria in July 2007. Focusing on African countries, the mission of the Institute is to develop tax policy and tax administration capacity within the public sector, offer appropriate postgraduate programs in tax policy and tax administration, to offer special contact and distance learning short courses on current tax issues to officials at national, regional, and local government levels, and to facilitate, undertake, and disseminate tax-related research on African tax issues. In 2009, the ATI commenced with a multidisciplinary master's program in tax policy and administration. And in 2021, we welcomed the 12th intake of master's students. To date, more than 150 students have graduated. The majority of these students work for African revenue authorities or ministries of finance. In 2012, the ATI also commenced with a PhD in tax policy. However, a number of doctoral students in tax law from the Faculty of Law have also been supervised, and since 2010, 18 ATI doctoral students have graduated with a PhD or an LLD degree, with 6 of the students winning the award for best thesis in taxation in South Africa. In March 2020, the situation for students and staff changed dramatically when borders were closed and many countries went into an unprecedented state of lockdown. We soon realized that it was a matter of adopt or die. Staff and students simply had to adapt to this unique situation. In 2021, the whole master's program is now offered online. Despite the various stages of lockdown, ATI staff remained actively involved in research endeavors and in collaboration. For example, the ATI continued its collaboration with the Center for Taxpayer Rights, with Nina here with us in the US. We collaborate with the Lincoln Institute of Land Policy in the United States, the International Center for Tax and Development at Sussex University in the United Kingdom, and the Vienna University of Economics and Business in Austria. Please take note that apart from the ATI, studies in taxation at undergraduate and postgraduate levels are also offered in the Department of Taxation, which is in the Faculty of Economic and Management Sciences, and also in the Faculty of Law. The Center for Human Rights, which is in the Faculty of Law, and a number of our colleagues have been involved in organizing this conference, is a great avenue we have in the university, which can facilitate interdisciplinary and multidisciplinary research. Tax and human rights is thus one of the apt interdisciplinary subjects we are pursuing. Well, despite all odds, here we are today, hosting the long-awaited 6th International Conference on Taxpayers' Rights. We would have loved to welcome you in person in Pretoria at the university's beautiful main campus. How we planned, Nina, how we planned. We are, of course, still pleased to welcome you virtually to this prestigious event, and we wish you great deliberations on the conference theme, Taxpayer Rights, Human Rights, Issues for Developing Countries. Thank you so much for honoring the invitation to participate in this conference. Thank you.
Thank you.
Over to you, Nina.
Thank you, Annette. So I'm just going to take a few minutes as, convener privilege to share some thoughts that have come to me over the last 2 years as we originally planned the conference, and then as we watched the world sink into a COVID environment. As I've said before, in the United States, taxation is not couched in the language of human rights, and taxpayer rights are not often thought about in that context and in the framework of human rights. In fact, when we were able to pass the Taxpayer Bill of Rights, which I first proposed in 2007, it was seen almost as a public relations tool after the IRS had gone through a very difficult scandal dealing with implications of it politically interfering with certain nonprofit organizations. And adopting a Taxpayer Bill of Rights seemed like a good message, a reaffirming message to taxpayers. But the intellectual foundations and legal foundations for that document in the United States is still being explored and will be explored for the next, I don't know, generation at least, before we get much clarity. As I've worked with others and I've seen other constitutions that explicitly address taxation and the relationship of the government to its taxpayers and collective rights and individual rights, it's really struck me as someone from the United States how much we have to learn from other countries. COVID has brought that into great relief. It has made clear, I think, to everyone around the world what the role of taxation is and how taxation provides the revenue for governments to meet the needs of their people. And you are beginning to see a change in the United States in that dialogue. As I say, mostly we don't think about the fact that taxation is the means to provide public goods. But what you are seeing now with some of the debates as part of COVID, where the Internal Revenue Service became the major lifeline for people, distributing massive amounts of funds to families in the United States throughout 2020 and into 2021. And the legislative proposals that are being, debated right now is the recognition that the tax agency touches every single individual in the United States in one way or another, or has the capacity to. And the system itself is the vehicle of providing public goods and public welfare. And that is really what this panel is about, is what is the relationship of government to its people, and what is the role that taxation plays? And then how do you ensure that that system is fair, even-handed, and equitable? Where do the rights of the individual and where do the collective rights of the people come into all of this dialogue? And that is what I hope we will have today, is a dialogue, starting with a dialogue among the panelists and then a dialogue among all of you who are attending. Please feel free to write comments or ask questions in the chat. And we have tried to reserve time at the end of each panel for you all to discuss and raise questions as well. So with that, I'm going to, a little bit early, turn it over to our moderator. Most of our panelists are here for our first panel, and one of them is on another call and will be joining shortly. But I think we can kick off now. Hello, Frans. All right.
Yes.
So I will hand this over to you to open the first panel.
Good afternoon, everyone. We are really privileged to have a wonderful panel together with us this afternoon, who will be speaking around the topic of tax and human rights. Essentially, I think it's a very good entry point into the issues around taxation. Perhaps it's not the first thing that comes to mind when one thinks about tax, but I started to think about it, Nina, and I realized that tax is really at the heart of our endeavor to realize the human rights of our citizens. In South Africa, at the very least, we think in terms of well-being defined perhaps as socioeconomic rights entitlements. So clearly, if one has a functional and effective taxation system in place, that goes a long distance towards ensuring the realization of these basic socioeconomic rights. So from that perspective, tax certainly has an impact on the collective rights of our citizens, potentially really all taxpayers. If we think of value-added tax, being some form of compensation, some forms of consumption tax being in place, clearly we have a system in place in most societies where we are all taxpayers. And in other words, the benefits of this tax is there to somehow support the notion of our rights being realized. But on the other hand, maybe the perspective that most people would come from would be looking at this from the individual perspective, the individual taxpayer perspective. What are the rights of the taxpayer as an individual? Clearly, we think here of a system that treats people fair, so that there's a legitimate system in which people feel comfortable to participate. They feel that their rights are protected as taxpayers. There's a system that's transparent, where we know what we can expect, and that the outcome would be that we are not paying more than what we are due as taxpayers. The rights to confidentiality, privacy, freedom of information, all of those come into play, obviously, as far as the individual taxpayer is concerned. So I think much of our discussion could be between this balancing of the focus on the individual, the taxpayer, his or her rights, and then the broader implications of tax in societies that are fundamentally unequal, and how also the collective socioeconomic rights concerns could be addressed through our tax systems. To that, in our discussion, I'm sure we'll also broaden out to the international dimension. In a context of growing globalization, evidently, the way in which money also finds its way around the world impacts on taxation. We are all familiar, I'm sure, with issues around tax havens and new and complex ways of tax evasion. So that brings into discussion many other questions about regulation and about responsibility that I think our panelists may also touch upon in the context of this broader discussion of human rights. So we have 4 panelists as indicated, and we thought that we will invite Judge Dennis Davis to take the floor first. Judge Davis, as I think you could see more clearly and fully in his curriculum vitae, which is in the conference materials. He is a seasoned academic and practitioner in the field around tax law, but also in human rights. He has been involved in the drafting process of the South African Constitution, technical expert. He has written on some of the first publications around this, rights and the Constitution, and he also has a great expertise around a number of areas, including labor law and then also tax law. He has served as a judge of the High Court and as the president of the Competition Appeals Tribunal. He has also had a stint as a judge on our Supreme Court of Appeal in South Africa. And I am very happy, very fortunate, Judge Davis, to introduce you. And the panel, I'm sure, will listen to you, and so will our audience, just to confirm that our understanding, although we run a little bit early, we ask our panelists to keep to around 15 minutes or so. And I will make some gesture if perhaps that will just be a reminder at some point to also keep us all on that time frame. But thank you very much, Judge Davis, and over to you.
Thank you very much, Frans, for that very generous introduction, and to Nina Olsen for organizing a conference that I deeply regret that we can't be in person, which would have been so much more fun. But the fact that you've organized it in this particular way is a credit to all of you and to my South African colleagues as well, Real and Annette et al. And thank you so much for inviting me. I am approaching this topic in a slightly different position to that which I might have about 6 months ago, prior to my retirement from the bench. I say that because earlier this year, I agreed to consult for the South African Revenue Service. So I'm all of a sudden, having started my life off as a tax consultant before I became a judge and a practitioner within the courts in this regard for taxpayers, then becoming a judge and having to deal with a whole range of tax cases, which basically required, as it were, a level of neutrality. Now I find myself on the other side of the fence. And I think I want to offer some perspective with regard to that, as will become apparent. Let me try, as it were, to illustrate the point I'm trying to make. When I was a very young criminology postgraduate student in a previous life of mine, there was a famous article written by Herbert Packer, which talked about the crime control and due process models of criminal law. And the idea was that there was a trade-off between, as it were, very tough crime control measures on the one hand, and recourse to due process on the other. And the question was, where did you strike the balance? For after all, the society had an interest, a clear interest in ensuring the curbing of crime, but on the other hand, it also had a significant interest in ensuring that even people who were accused of crimes were given due process. And it does seem to me that's that particular conundrum with which Packer was grappling all of those years ago, albeit in a different context, is particularly relevant to the topic with which we're engaged this afternoon. And may I just add, even more so in developing countries. But perhaps I've run ahead of myself. So if we look at the question of taxpayer rights in South Africa, notwithstanding that our tax commission, which I chaired, the Davis Tax Committee, in a paper authored by my dear colleague, Professor Thaba Legwala, we did call for a consolidated version of taxpayer rights. Now, to some considerable extent, that would mean as it were, a significant implication, a significant implementation, if I could put it that way, of rights which already are in the Constitution and in legislation which was implemented pursuant to the Constitution, but which would make it more practical for taxpayers to use these rights. Let me explain again. South Africa is in a unique position whereby in the Bill of Rights, which it crafted in 1996, it included a right to fair administrative action, and one, as it were, to access to information. And pursuant to that, there two pieces of legislation were passed pursuant to the doctrine of what I suspect we call in South Africa, and probably elsewhere as well, the doctrine of subsidiarity, which means that you don't have your cause of action directly under the Constitution, but in terms of legislation passed to give vindication to those rights. And the right to fair administrative action was concretized in the Promotion of Administrative Justice Act, and the right of access to information in the Promotion of Access to Information Act. Now, I can't obviously, at the moment, I'm actually teaching a whole course on this. And so let me give you the 3-minute version. So the 3-minute version is that both of these particular pieces of legislation give taxpayers considerable rights. The fact is that a vast swathe of decisions taken by the Commissioner of the South African Revenue Service are reviewable pursuant to the doctrine, to the concept of administrative action. Let me give you an example of what I mean. We have a principle called the pay now, argue later principle, which of course is significantly relevant in all sorts of ways to everything we're talking about. Because the truth about it is, once the taxpayer has been assessed by the commissioner, then there's a payment of the money, and then you can jolly well go off and try to exhaust the various range of remedies that you may have. And the legislation as well does in fact allow the commissioner, as it were, to postpone the demand for payment pursuant to settlement of the case. And that discretion itself has, as the courts have held in a number of cases, the one I have in mind for South African audiences, the case of Capstone of 2011, judgment of Mr. Justice Binns Ward, where he quite rightly points out that the very fact that the commissioner can exercise the discretion, that the commissioner can decide to stay the payment demand or change his or her mind in regard to this, is clearly a reviewable decision, and courts can review it, right? And that would play right along the value chain in relation to assessments. So what I'm trying to suggest is that on that line, and again, forgive me, given the limited time that I have for basically dealing with this in a telegrammatic fashion, but it is a powerful form of review, and it means, and even if in South African law, the rather poorly drafted definition of administrative action under the Promotion of Administrative Justice Act, even if the commissioner can escape that, all and every act of a public exercise of a public power is subject to the principle of legality, and we've developed a principle of review in relation thereto. So my simple point is, there's a vast armory of rights which taxpayers have with regard to every single decision taken along the line by the commissioner. I'll come back to how that should be implemented in a moment. The same is true of the access to information. So thanks to this PIA, which essentially flows from the right of access to information in the Constitution, taxpayers in South Africa are entitled to request information from the Commissioner of Inland Revenue insofar as that information relates to the taxpayer. If a taxpayer requests a copy of her file held by the Commissioner must provide the taxpayer with a copy when called upon to do so, etc. So again, significant rights available. What's the problem? The problem, as always, isn't in the rights. It's in the way in which people can vindicate their rights. Now, I'm quite sure that my esteemed colleague, Judge Ngoepe, will talk about this with far more knowledge than I have. But it is true that we have a tax ombud. It is also true that tax ombud needs to be given more extensive powers. Because if you want to review something of the kind I'm talking about, you have to proceed to the High Court, which is both expensive and may well be time-consuming. And then, of course, it's subject to all sorts of appeals. So for many taxpayers, particularly individual taxpayers and small corporations, the fact that they are armed with a plethora of rights does not necessarily, in effect, give them, in reality, that which is promised in the Constitution. And one of the issues I think we should be focusing on in South Africa is empowering the office of the Ombud with far more extensive powers, because that should be the route in which for many, many taxpayers, these constitutional rights are properly and adequately implemented. And that indeed would go also into a range of expedition, which is required from the Revenue Service in relation to responding to queries, objections, and appeals. That having been said, in a developing country like South Africa, and I'm particularly conscious of time, so I've only got about 3 or 4 minutes left. In a developing country like South Africa, one has to come back to my first point to achieve a balance. Allow me to explain what I mean. Now that I've been consulting for SARS and sit in on the litigation discussions that SARS has prior to bringing cases, it is absolutely clear to me that we've got a whole host of cases where people, and I'm afraid to say, this comes down to the question of the manner in which in which tax professionals actually represent their clients. We've got a whole lot of cases where we have to go through interlocutory application after another with all sorts of objections and reviewable points being raised by taxpayers in circumstances where the actual case involves not tax avoidance as much as tax evasion. And that really, and in certain cases, I've already come to the conclusion in 2 cases that we need to report very well-known tax professionals to the Legal Practice Council for really essentially unprofessional conduct. And so the question arises as to how one achieves a balance. We have a case now, to give you an illustration, which creates the problem, whereby a very large commercial bank is alleged to have been involved in a very significant avoidance mechanism. There's a manner in terms of our GAR by which, if, for example, the Revenue Service seeks to invoke the tax avoidance provisions, it has to issue under Section 80 capital J of our Act a notice giving the taxpayer, understandably, an opportunity to respond, and time limits are attached thereto. And then, of course, what occurs is that the commissioner will have to consider that and then decide whether to invoke his or her powers under GAR. What has happened in this particular case is that the bank immediately rushed off, not through the mechanisms of objection, appeal to the special income tax court set up for that purpose, rushed off to the High Court to say that the Commissioner has no basis by which to issue the notice because we didn't involve ourselves in impermissible tax arrangement, said the bank. And the judge accepted that, which means that's the end of the story. Now, the difficulty is that it's enormously difficult for the Revenue Service in an application of this kind, which is determined on the papers, on the affidavits, to lay out sufficient without, in a sense, having the benefit of examination and cross-examination of the whole gamut of the transaction to basically even begin to invoke these powers. And so what occurs in a case like this is that the review mechanism subverts a very significant part of our tax system. And now, why is this important for developing countries in particular? Because, and Frans has alluded to this in more general terms, because it is the developing countries who basically pick up the short straw when it comes to broad global tax evasion and sophisticated forms of schemes, precisely because they don't necessarily have, as with us, the capacity to deal with all of these. And secondly, if you take a country like South Africa, where quite frankly, we are in terrible, terrible financial shape. And now we can argue about that to the cows come home as to why. But the reality is we cannot any longer increase taxes. It's not an option open to us. So the only way we can in fact collect the kind of money which is required for the reconstruction of the society is by ensuring a more efficient form of tax collection. And therefore, the point I'm making is that whilst I wish the Ombud to have greater powers and to have expedition in vindicating the rights that the taxpayer has, consideration has also got to be given to the interests of society at large, namely that the Revenue Service should not have to go through absolute extraordinary obstacles, or what we in South Africa in a different context call the Stalingrad approach to litigation, in order to collect the money which is desperately needed if 60 million South Africans are to live in some level of dignity. And it is those kinds of challenges, I don't have answers to them necessarily, but it's those kinds of challenges that I feel I wanted to put out to this panel this afternoon, and I'll leave it there.
Thank you so much, Justice Davis. And I will not attempt to summarize in any way, but just to thank you for highlighting the access to information, rights of taxpayers, the right to fair administrative process, but highlight in particularly with reference to South Africa as a developing country, the gap essentially between the rights and their implementation and issues of capacity and how that all makes the rights sometimes illusory. I want to just with reference to the chat box, welcome and note together with you just a wide array of participation. So I know that it's not necessarily representative of who we have in the room, but we see that we have people from the Philippines, from the United Arab Emirates attending, from Belgium and Poland, and then in Africa from Mauritius, Cameroon, South Africa, Nigeria, Uganda. Those are only the ones who posted words of welcome. We say thanks, and perhaps then remind all of us, you are most welcome to insert your own comments of welcome, yes, but also in response to the presenters, the panelists. If you have questions or you have comments, please insert them in the chat box and we will revert to them. After the four presenters have made their inputs, we will take your questions and comments and ask them to deal with those. Let me then move to the second panelist, Judge Ngoepe. Good afternoon, sir. It is a privilege to have you here too. I've been told by the organizers, by Nina, not to repeat what is in people's CVs, but I'll say three things about you, Judge Ngoepe. Judge Ngoepe was, among many other things, the Judge President of the South and North Gauteng High Court in South Africa. He was, which is close to my heart, a judge of the African Court on Human and People's Rights, the first South African to sit on that Continental African Union Court. And now he is, as I think all of us know, since 2013, the first and then the only tax ombud that South Africa has had. I think we stand to benefit greatly from your inputs this afternoon, and the floor is yours, Judge Ngoepe, please.
Thank you. Thank you very much. Good morning, good afternoon to everybody. It's an honor to be here this afternoon, to be involved in this discussion. Thank you for the invitation, and thank you, Frans, for saying only good things about me when you introduced me. You had a lot of bad things you could have said about me, but thank you very much. I think my approach might be slightly different to that of Judge Davies, but not so much so. But perhaps keeping to the topic as proposed, I should say that in this country we don't have a taxpayer's bill of rights. Perhaps it's not we're not unique in that respect. But what we do have is a constitution. And what I'm pleading for is that what is needed is creative thinking. You may not have a taxpayer's bill of rights, you may have a constitution. We do have a constitution, but what is needed is for us, for practitioners, tax practitioners, the courts and so forth and so on, to come up with some creative thinking in the interpretation of that constitution, interpret it in such a way that you will find some protection that is extending to taxpayers. Nina said something right at the beginning. You said something like, maybe in your country, things are not couched in taxpayer language, even less so in this country. In fact, in this country, if you talk a lot about taxpayer rights, it is the executive would view you as if you are frustrating tax collection, which is not true, because if you treat people with dignity, with fairly, in the manner that they should be treated, they will be encouraged to be tax compliant. So back to the constitution, as I've said, if you look at it, you will find that it does extend certain rights. There are general rights, but there are the rights which can be extended to taxpayers in that particular context. For example, the right to equality. We have sought to say, when you collect tax from people, you must do so fairly. Treat everybody the same way. And this is not just an empty statement. It's not an academic statement. We have seen in this country that when it came to the collection of tax, some people were more equal than others. Some people were actually protected. The regime at some point, the regime of tax collection at some point, patently discriminated against certain people, in the sense that some people are shielded from proper tax collection because of their political positions. And when they came to ordinary people, they came down rather heavily on them. And now that's a clear discrimination, treating people in a manner that is not equal. Now we do have that kind of problem, and we would say that that's the kind of thing that should not happen. And let me interrupt myself here to say, you know, it's all very well to have certain rights, but as Judge Davis said, it's another thing when it comes to the vindication of those rights. But I'll come back to that later. But one of the rights that we always try to argue a taxpayer does enjoy under the Constitution is the right to privacy. And in that area, there isn't much contestation, because SARS readily accepts, that is, the tax collector readily accepts that that kind of privacy should be upheld and observed, except that under certain circumstances, of course, it can be limited, as I will indicate later. Well, we do have a constitution which seeks to treat people, to give people certain rights, political rights, and all sorts of rights in society and the like. And our view is that, has always been that we should have a taxpayer bill of rights, which would concretize all those rights, make a collection of those rights from the Constitution and translate them more relevantly and extend them more relevantly to taxpayers so that they could be better protected. It would be easier to protect them. Of course, one of the rights to what people enjoy under the Constitution is the right to dignity. And that right sometimes is not observed when it comes to the treatment of taxpayers. You find that they're treated by tax authorities in a manner that is not recognizing their sense of self-respect and dignity. Now, all these things can be done and should be done even under the Constitution that we have. I don't know about other constitutions in the country, but at the end of the day, the responsibility falls on the judiciary and all those law enforcement agents to make sure that all those rights that are enjoyed under the Constitution are also enjoyed even as they go about collecting tax. I've said earlier on that one of the problems we have is failure to recognize the importance of respect that must be accorded to taxpayer rights. And that has been clear in the manner in which, for example, the government has been very slow in, for example, strengthening the office of the tax ombud. We have been trying to argue that this office should be independent of tax authorities. It should be an independent institution with its own resources, including its own pairs, to make sure that it is effective in protecting taxpayer rights. But you do not easily enjoy that kind of cooperation from governments. Judge Davis has referred to the aspect of vindication of taxpayer rights, particularly through the office of the tax ombud. If that office had been strengthened, if that office had been given the necessary resources, it would be a lot easier for taxpayers to enjoy protection, because that office works expeditiously, and importantly, it does so, it renders its services free of charge. But we don't have that kind. We have not reached that stage. We have been struggling to do that. Hopefully one day that would happen. Now, turning to the courts, the difficulty with the courts is sometimes that they lack specialty in terms of tax knowledge and interpretation of tax laws and their application. Judge Davis has referred to one instance where things just became difficult for the tax collector. Sometimes it works the other way around. Sometimes you'll find judgments that are, well, I don't want to be disrespectful, but some judgments which are difficult to comprehend in relation to the protection of taxpayers' rights. But another thing, of course, with regard to the courts is that they are expensive. Litigation is very expensive. We do have the Promotion of Administrative Justice Act in this country. It goes a long way towards assisting in the vindication of the rights of taxpayers, but it doesn't go far enough. We need an independent and effective mechanism like the Office of the Tax Ombud to make sure that the taxpayers are adequately protected. Let us, of course, not forget that to every right there are obligations. Taxpayers need to understand that there's an obligation on them. I'll refer to it later on. there's an obligation on them to pay that which has got to be paid. I always say a taxpayer must not be made to pay 1 cent more than they should pay, but at the same time, I turn to them and say, you must not pay 1 cent less than what you should pay. And I think in that way, then the system would work better. Now, of course, it is important as to how the executive or those whose duty it is to use tax. It's important for them to use it properly in a manner that would inspire confidence in the people, in those who have got to pay tax. And if they don't, then you have a problem with people resisting to pay tax because they have a feeling that it's not being properly used. Perhaps I should say they've got the right to demand that the tax they pay is being used properly. It is part of their right to do so. Yes, on that point of the protection of rights, I think some balancing is needed. Some balancing is needed. Yes, privacy is needed on the part of taxpayers, but the tax collectors need to have some access into certain situations. And if some rights have to be restricted here and there, so be it. But what is important is the balancing. Now, we're talking here also about issues of international tax havens. Now, I connect that with, again, with the issue of human rights in this way. For example, the African Charter on Human and People's Rights makes it an obligation. It imposes a duty on every citizen to pay their taxes, precisely because it is being appreciated that without revenue, people's basic rights would not be realized because you need money to do that. So the African Charter imposes that obligation specifically on people to say, pay your tax. Now, in my view, if there are some tax havens abroad to which monies are taken, which should have been used here on the continent, I think those tax havens are complicit in the violation of human rights. They are complicit in assisting people to breach that obligation, that international obligation imposed on them by the African Charter to make sure that they pay their taxes. They are complicit in helping them to avoid, in fact, evade paying tax here on the continent, which badly needs that money. And I think we should say to them that as you provide that haven to people, you are clearly violating people's rights. You are complicit to that because you encourage them to violate the duties to pay tax, which is so badly needed in that. And we need to make a lot of noise about that because it's very crucial that money should be kept on the continent. So some of the consequences that we see in terms of failure to observe and protect human rights, particularly, let's say, nationally, is the basic lack of understanding on the part of the authorities that are about connection that exists between economic development on the one hand and the realization of human rights. If you corruptly use tax that you have collected, if you steal tax, which is supposed to help the poor, I think you are actively involved in the violation of people's rights. You are actively involved in condemning people to a condition of want, of hunger, and lack of basic services. It's a criminal conduct on the part of those people. So just to sum up on these issues, I believe that indeed we do need instruments that should protect the taxpayers' rights. But in some instances, we do have those instruments. But even where we do have those instruments, we need machineries that will be effective in vindicating those rights. Efficient courts that command the necessary expertise in terms of tax matters. We need practitioners who are committed to their profession and who would make sure that the necessary balance is achieved between, on the one hand, the taxpayer's rights, and on the other, the tax collector. It is for that reason that we need very strong stakeholders in the regime of tax collection, outside of the state machinery, in terms of the professions. We need strong professions that would advocate for the protection of the taxpayers' rights. It is for that reason that personally, I have made sure that my office keeps on interacting with these stakeholders, these tax bodies that are in private practice. The concern that Judge Davis has expressed about some of them perhaps not conducting themselves properly is a well-known one. I personally have spoken about that issue to say that if you are a professional person, you are complicit in systems to evade tax payment, you violate people's rights, the poor that would have benefited under tax that would benefit them. In fact, I have said that it's not only criminal to help people evade tax, but there are some very aggressive tax plannings that are in the form of tax avoidance, but they come very, very close to being criminal, very close to being tax evasion. But anyway, I think the responsibility at the end of the day is not only on the tax ombud, it's not only on Professor Viljoen, it's not only on Nina, it is on the professions themselves as well, on the government and everybody else involved to make sure that we produce that necessary balance in terms of balancing the taxpayers' rights on the one hand and tax collection on the other. It's only once we are able to achieve that we'll be able to collect the kind of tax that we want to collect and be able to realize the very basic human rights of the people. Thank you very much, Prof. I hope I haven't exceeded my time.
Thank you very much, Justice Ngoepe. That was perfect timing, and thank you so much. I think you made remarks that also linked back to Justice Davis, and showing the implications for the right to equality, privacy, dignity, reminding us that rights may be limited, but that we are seeking to find this balance. Again, maybe appreciating particularly your reference to the African Charter as our continental framework, where there is, as you indicated, the duty to pay tax on a personal level. And I think you made a very convincing and passionate point that breaching that duty is not just a breach of the African Charter as such, but it's also violating the rights of those to whom the tax would have meant the most, probably the masses, the great numbers of poor people in our countries and society. So thank you so much, Judge Ngoepe. I see in the chat box we have two new countries announcing themselves, just to say that Italy and Austria are also, Australia, sorry, Australia and Italy are also represented among our participants, and reminding everyone that you're most welcome to insert your comments and your questions in the chat box at any time. So we move to our third speaker. The next two speakers are women, and for no reason of a lesser worth, but just, I think, because we took the two justices first, and therefore we go now to Professor Patricia Brown, who is with the United Nations Department of Economic and Social Affairs, and specifically with the Financing for Sustainable Development Office, and she's based in the United States. Professor Brown, you're most welcome, and we very much look forward to also you sharing with us your considerable experience within this field. Thank you so much.
Thank you so much, and thank you for the invitation to speak here today. It's been a very interesting discussion so far. I was reminded during Judge Ngoepe's comments of when I took my bar exam, and I don't remember many years ago, before there were Taxpayer Bill of Rights. But the only thing I really remember from the exam is that when I got to the question on New York State tax administration, and I broke into a cold sweat. And then, because of course I knew nothing about New York State tax administration, but I did know the Constitution. And so I wrote my answer based on the Constitution and passed. And so the rest is history. So, I think that taxpayer rights are grounded in our constitutions, but they go back further than that. And I want to zoom out maybe a little from where we are to look at this question of collective versus individual rights. And of course, coming from the United Nations, I suppose it's possible to go back to the Magna Carta, but I'll start with the Universal Declaration of Human Rights in December 10th of 1948. And, as described on our website, it's a common standard of achievements for all peoples and all nations, and sets out fundamental human rights and that are universal. And what's interesting is that if you look at the Universal Declaration of Human Rights, there are lots of documents from 70 years ago that don't stand up, but the Universal Declaration does. You can look at it and say, yes, this is right. Of course, taxpayer rights derive particularly from the articles dealing with due process rights, privacy, and property. But it's also important to look at which of those rights are qualified and which are unqualified. So, for example, there's a statement that says everyone is entitled to full equality to a fair and public hearing, whereas the rights to privacy and the rights to property are qualified. They are they're subject. They are people are protected against arbitrary inclusions or arbitrary deprivations of those rights. And so there is already in the Universal Declaration this concept of balancing that we see further on. I think the other point that struck me as I was preparing for this is that we do have, when we say that there are rights that are universal, they are modified or affected by our culture and our society. And to take, for example, there is a right to due process, but how that occurs in each country is going to be affected by our legal systems. And I was struck by that forcefully in a conference run time when we were talking about an arbitration system, and someone from a civil law country said, well, sort of, you have time wasted. You should be able to go straight to arbitration if it's clear you're not going to be able to reach an agreement in the competent authority system. And the countries from, it took a minute to realize the countries from a common law system, we base our system on an adversarial system. So the process of fleshing out the facts is part of the process itself. And many civil law countries don't have that. It's much more top down. And so our adversarial system has a system of affidavits, interrogatories, depositions, very based on fact finding and the competing positions of the two parties. Neither is better than the other. They're just different. And so when those universal rights get translated into different countries, it's going to be affected by that fundamental system. So that process of taking very general statements and translating them into specific goals or rights also is reflected in the United Nations 2030 Agenda. The Sustainable Development Goals include or intended to realize, as they say, realize the human rights of all, and they are integrated and indivisible and balance development, economic, social, and environmental. And again, you see this balancing. There should not be, you don't have to choose sometimes, but you shouldn't. When you look at the Addis Ababa Action Agenda, which focuses on the financing of the Sustainable Development Goals, the focus there is on domestic public resources. As the judges have said, we cannot achieve human rights for all unless we can actually collect the taxes. And that's reflected in the Lima Declaration on Tax Justice and Human Rights, which was written in 2015. It's supported by close to 200 civil society organizations. And again, it says the most reliable and most sustainable instrument to resource human rights is sufficient, equitable, and accountable ways, or taxation is that. And so I think that is almost, it is the standard. We've talked about the African Charter. And so it should be possible to collect the revenue necessary to provide for these human rights without violating the individual rights. And I think we have those systems in place. So keeping in mind the time, I want to focus very quickly on confidentiality as an example of this. And I decided this before the events of the weekend, so it's sort of an interesting time to say this. But, the right to privacy is widely accepted as a fundamental human right. In many countries, taxpayer information is viewed as particularly sensitive, although in other countries, individual taxpayer information is publicly available. And so I don't think that there is one universal standard protecting taxpayer information. And in fact, even our tax treaties and information exchange agreements don't set out that standard. But we do have those agreements. We have a system of agreements that build in some taxpayer protections. But what we're seeing is these high profile leaks of information. And what I think they are a system, again, going back to Judge Ngoepe's comments regarding taxpayer confidence in the system. I think they are a symptom that the public doesn't have confidence in the system. They don't believe that the rich are paying their fair share. And so you have this almost vigilantism that's going on, and that will persist, I think, unless there is confidence. And part of the problem is that developing countries are not fully participating in the system of international agreements. They're not getting the information that they need in order to collect the taxes that will support the human rights for all. And so while in an ideal world, the collective and the individual are not in conflict, in practice, we have an imperfect system, and we have to find a way to provide the support to developing countries, get information to developing countries so that they can support the human rights to which everyone is entitled. So in the interest of time, I'll stop there and pass over to the next speaker.
Thank you very much, Professor Brown, for your reflections and also taking us back to a number of themes that had already been raised, looking at the balance between the individual and the collective, and also spelling out, in a sense, the importance of public trust and the consequences when this trust is eroded. And I think bringing us also back to the concern for developing countries and how specific issues resonate differently and in a specific way in these countries. And I'm sure in the discussion we may come back to this issue. The last speaker on our list of 4 is Asha Ramgobin. And Asha is the Executive Director of the Human Rights Development Initiative. I have known Asha for some time. I know that she is quite passionate about issues around justice generally, social justice, tax justice, and we look forward, Asha, to your contribution to this discussion today. Thank you, and over to you.
Thanks so much, Frans, and thank you to my fellow presenters. Thank you to Nina. I am exceedingly honored and very truly humbled by being invited onto this panel, and even more humbled because I come from a simple law clinic background where I worked on access to justice for various vulnerable groups, and more recently for people living with HIV. As part of this work, and during the work with people living with HIV, we argued that the right to health was more than about just the right to medication, that it was about clean running water, that it was about sanitation and a range of other things. And but the question always arose as to where was the money going to come from for this? Governments often would say we simply don't have sufficient money. It's in this context that I first came across the issue of illicit financial flows and realized that Africa loses more money through illicit financial flows than it receives in aid, loans, and investment combined. And this piqued my interest, and it's from there in about 2012 that I started to study this field and engage with it more as a human rights issue. So at the time when I discovered this, I actually thought that it was the big men and women of Africa, that the elite, the corrupt, that robbed us of our resources. And then through these reports on illicit financial flows, I learned about the bigger picture, about corporate theft. And as I learned more, I learned about how corporations manipulate invoices to show high profits in countries with low tax rates and to show low profits in countries with high tax rates. And from then, Gandhi's words echoed in my mind when he said, all amassing of wealth above and beyond one's legitimate needs is theft. There would be no occasion for theft if there was wise regulation of wealth and social justice, close quote. And it is precisely because we do not have wise regulation of wealth in our individual countries and at the global level that such theft is even possible. The UN Conference on Trade and Development tells us that the inordinate levels of inequality that we see in the world today is a result of an extreme form of globalization, where the financial and currency markets are deregulated in a way that makes it possible for corporations and wealthy individuals to hide trillions of US dollars untaxed in tax havens. We will not mention Pandora yet. The network of tax havens and offshore secrecy jurisdictions date back to the decolonization period. Professor Vanessa Ogle says that it was a result of concrete, deliberate, and conscious collaboration between colonial states and corporations. In the 1950s, when the settlers realized that the wave of independence was upon them, they looked for ways to repatriate their money and transform their assets without paying tax to the UK or to the colony. Instead of insisting that they pay tax to the welfare state, Britain enlisted the services of Price Waterhouse and Company to help its overseas territories evolve into tax havens, so that they could receive these funds from returning people and corporations of the empire. Through this, Britain found a way to reduce their aid to its crown dependencies and overseas territories and solve a problem for those returning from the colonies. Today, these tax havens are used to shield the wealth of corporations, politically exposed people, and high net worth individuals. But over and above that, tax havens also help those who use them to escape other regulations, launder money, hide money from partners or spouses, and secure secrecy for their commercial activities. We see this message reinforced in the Panama Papers, the Paradise Papers, the Mauritius leaks, the Luanda leaks, and now in the Pandora Papers. But rather than dwell on the celebrity of these leaks, I would like to highlight that the Kenyatta family that was exposed now in the Pandora leaks, for example, they did not design the schemes. Instead, it was lawyers, accountants, bankers, fund managers, and tax experts who ensured that the system evolves, adapts, and mutates in the face of internal and external threats. It's these groups that designed the schemes. In 1930, Gandhi described a lawyer as an advocate of people's rights, an expert in law and politics, and one who saves victims of oppression by the state. But even earlier in 1927, he suggested that if we wanted to spiritualize the practice of law, we must first and foremost not make our profession subservient to the interests of our purse, but instead to use our profession for the service of our country. Instead of serving our country, lawyers who enable illicit financial flows weaken the state, structures of government, and other institutions such as financial intelligence units, legal regulatory systems, financial regulatory systems, and of course, revenue authorities. But over and above that, beneficiaries of illicit financial flows continue to undermine those institutions that are responsible for detecting and prosecuting illicit conduct. Through bribery, corruption, and public theft, beneficiaries of illicit financial flows also discredit democratic institutions. And these weakened systems and institutions are then not able to address other forms of crime and illicit conduct, thereby giving free rein to crime syndicates and other opportunistic forces. We are living in a time when the boundaries of what is considered acceptable corporate conduct has been stretched to the limits. The network of tax havens, secrecy jurisdictions, and international financial centers are also used to hide ill-gotten gains. But more than that, they also tilt the distribution of the costs and benefits of globalization in favor of the global elite, thus deepening inequality in the world. And once again, Gandhi's words come to mind. And he said, I quote, "Economic equality is the master key to non-violent independence. Working for economic equality means abolishing the eternal conflict between capital and labor. It means the leveling down of the few rich in whose hands is concentrated the bulk of the nation's wealth on the one hand, and a leveling up of the semi-starved naked millions on the other. A non-violent system of government is clearly an impossibility as long as the wide gulf between the rich and the hungry millions persists." He stressed that the contrast between rich and poor, palaces and shacks, huge malls and hovels of the poor, laboring classes, cannot last one day in a free country in which the poor will enjoy the same power as the richest of the land. For Gandhiji, a violent and bloody revolution was inevitable unless there was a voluntary abdication of riches and power that riches give and sharing of them for the common good. So to avoid this violent and bloody revolution, I would like to now look more closely at what we have in our human rights toolkit to help us tackle illicit financial flows and tax havens. So let us look firstly at the principle of solidarity in international law. Some scholars view the notion of solidarity in international law as a unicorn, a fairy tale, or some other mythical notion with no substance in reality. On the other end of the spectrum, there are those who argue that solidarity is and has been a core component or structural principle of international law. Judge MacDonald of the European Court of Human Rights has this to say about solidarity. He says, "Solidarity is neither charity nor welfare. It is an understanding among former equals that they will refrain from actions that would significantly interfere with the realization and the maintenance of common goals or interests. Solidarity requires an understanding and acceptance by every member of the community that it consciously conceives of its own interests as being inextricable from the interests of the whole. No state may choose to exercise its power in a way that gravely threatens the integrity of the community." He's obviously talking about the European community here. But applying this view to tax havens, I would like to suggest that perhaps the tax spillover assessment to address the impact, the direct impact of one country's tax policy on another country's tax base, tax policy, and economic activity might be a tangible way to put this principle of solidarity into practice. But perhaps this is me playing with unicorns again. One element of the principle of solidarity is the duty to cooperate. It is found in all the major human rights treaties at an international and regional level. However, Northern states rejected the notion that this duty to cooperate entailed a legally binding obligation, particularly a legally binding obligation to provide aid. While this may be so, and to some extent understandable, I ask the question, does the principle of solidarity and the duty to cooperate in international law not at least create both a positive and negative obligation upon states not to interfere in another state's ability to fulfill its obligations, and particularly in a community context with the objectives and common goals of the community? So if we look, for example, at the Southern African Development Community, state parties of Southern Africa undertook through a binding treaty to avoid harmful tax competition in Southern Africa. As part of this undertaking, they agreed that they would each avoid introducing tax legislation that prejudices another state party's economic policies. They also agreed to develop a common policy regarding tax agreements and a model tax agreement that will first prevent double taxation and second, facilitate the effective exchange of information and mutual cooperation among tax authorities. But despite the fact that we have these obligations in a binding treaty, we have prominent tax havens in Southern Africa, Mauritius and Seychelles being two of them. Notably, both the UN Special Rapporteur on Poverty and the UN Independent Expert on Foreign Debt stress that the obligation to assist and cooperate under international human rights law requires that states, and I quote, refrain from any conduct that impairs the ability of another state to comply with its own human rights commitments, close quote. This includes a situation where one state's tax policy affects another state's ability to mobilize its tax revenue to provide for the right to health, for example. The International Bar Association argued that a state is in violation of its international obligations, particularly with respect to economic, social, and cultural rights, if it encourages tax abuse and deliberately thwarts the efforts of other states to combat tax abuse. So the principle of solidarity and the duty to cooperate within international law provide potentially strong tools to address tax havens, but they obviously need to be sharpened and honed if they're going to be truly effective. Turning now to the concept of equality, the UN Independent Expert on Foreign Debt concluded that tax abuse by corporations and high net worth individuals erodes the right to equality in that it forces governments to impose regressive or indirect taxes, such as VAT, which negatively impact on the redistributive goal of taxation in the first place. The cases before the European Commission against Ireland, Netherlands, and Luxembourg regarding the agreements entered into with Apple, Google, Starbucks, and Amazon all turn to some degree on the question of equality and non-discrimination, albeit in the context of competition law. In 2015, the European Commission decided that tax rulings cannot use methodologies to establish transfer prices with no economic justification and which unduly shift profits to reduce the taxes paid by the company. It would give, they said that it would give that company an unfair competitive advantage over other companies that are taxed on their actual profits because they pay market prices for the goods and services they use. The issue of unfair competitive advantage highlights that the manner, shape, and form of these tax rulings create an unfair advantage over small and medium local enterprises and was consequently illegal under EU rules. A few words now on the concept of human rights balanced by duties. Moyne asks if states have an obligation, he asked this question, if states have a duty to provide housing and food, do individuals have a duty to pay taxes to ensure that it can do so? This then led another scholar to ask a question, to confront global inequality, is it not necessary to stress both the economic rights of individuals, example, the right to an adequate standard of living, and importantly, the duties of individuals, example, to pay taxes so that governments can redress poverty and inequality at home and abroad. Judge Ngoepe mentioned that in the context of the African Charter, which imposes duties on all persons, the African Commission found that given the resources at the disposal of the extractive industries, as well as the extent and nature of the communities who are reliant on the extractive industry sector, all the provisions relating to duty, individual duties, applied to corporations as well. Article 29.6 of the African Charter provides for the duty to pay tax. Unfortunately, we don't have full normative content on what that duty entails in terms of what obligations this places on states as yet, but it's there. As with the principle of solidarity and the duty to cooperate, the notion of duties also needs to be revived in the human rights discourse and harnessed in the battle against the harmful effects of tax havens. So I would like to close now by sharing Gandhiji's words and ideas again. Remember, we said, Uhuru Kenyatta and his family were not involved in designing the schemes that were exposed in the Pandora Papers. The King of Jordan and all the celebrities that were involved, the cricketer Sachin Tendulkar and all of them, they were not involved in the design. They're now being exposed, but they didn't design the system. It's the lawyers, the accountants, the tax practitioners that designed it. So Gandhi reminded us, and he said this, there is in English a very potent word, and we have it in French also. In fact, all the languages of the world have it, and it is no. He said that the secret that we have hit upon is the power of this no, particularly when it is accompanied by standing firmly with dignity and saying no. He reminded us that we always have had, that we still have, and always will have the power to say no. No as consumers, no as labor, no as lawyers, as bankers, as academics, and especially no as tax practitioners. We will not cooperate and not collude in fortifying this unjust economic order. Instead, we will find a way to change it. Thank you, Frans.
Thank you. Thank you so much, Asha, for that very passionate and informative, wide-ranging presentation. I think that touches on many issues that link back to what others have said, but certainly expanded the horizon of our discussion as well. Food for thought. I see there is one particular comment in the chat box. I'm going to read it and invite any of the panelists. I think you can see it with me. Someone who suggests that since terminologies do matter, and given that terminologies have an unconscious psychological effect on the minds of people, isn't it high time, Bunshu from Cameroon asks, that we replace the term taxpayer with the term investor? And he motivates by saying, because in essence, all taxpayers are investors, investing a portion of their earnings in anticipation of public returns, hence promoting the term investor rather than taxpayer would most likely positively alleviate most governments' approach towards citizens in guaranteeing their rights, and on the other hand, psychologically scrape off the burden-bound contributions mindset of those investors, thereby greatly promoting compliance. So perhaps as you may think about the terminological wisdom of such a term, I thought I can just maybe link to some of the remarks made by our speakers, and as we perhaps return, I thought that the issue of public confidence, Judge Ngoepe and Professor Brown in particular, you raised that, but certainly any of our panelists. So I think Professor Brown, you talked about how the exclusion, perhaps the non-participation fully of developing countries sometimes leads to a sense of alienation, perhaps, and a lack of inclusiveness, a sense of being included, and a public erosion that translates into having compromised tax systems. And I think Judge Ngoepe, you also talked about public confidence, and interestingly, I found you mentioned the right that one's tax be used properly, the right that one who pays tax, that tax money, that payment should be used properly, and then the obvious implication, if it is not, that it gives rise to public mistrust and a lack of confidence in those who in the first place are responsible for raising this tax. So I suppose my question is a little bit around how does one address through also retaining the balance that everyone spoke about, how does one perhaps most effectively address the issue of restoring public confidence in our tax systems, and what are the implications if that trust is broken to the extent that perhaps Asha talked about the specter, if you like, of revolution that she mitigated by reference to solidarity, to the principle of equality, to the concept of individual duties. So maybe if I could use the same sequence, I will ask that any of our panelists reflect on the first place on the terminological suggestion by Bunshu in the chat room, and then if you would want to reflect a little bit further on the issue around public confidence. I may say that we would invite certainly more comments, and we'll come back to the comments from the floor. But for now, could we take a brief-ish round to each of our panelists? Judge Davis, if we could again start with you.
Well, yeah, let me make a couple of points, Frans. Firstly, I don't like the term investor. It's a terrible term for me. And I'll tell you why. Because what this is about, you can use whatever term you like, this is about essentially vindicating a concept which is certainly one of ours in South Africa, but I think is broader than that. And that's the concept of Ubuntu, that I am only myself through you, that I am not an atomistic individual who ultimately is separate from the rest of the community. My fate is bound up with you. I pay tax so that my community can survive. Yes, in some, the return I get, I suppose, in some ways, is I live in a community, but I certainly wouldn't prefer to use a term which is connoted with returns. The key issue, which is exactly why we are in the trouble we are, is that we have moved into far too great a libertarian territory. The kind of anti-vaccinator sort of discourse that you have replicates itself throughout the world. Couldn't care less about anybody else. It's only what my freedom is, not yours. And until such time, and in South Africa, which is a pretty good example of this, by the way, the idea that people do not pay their fair share, and let's be blunt about it, that is the high net worth individuals, that is certain of the corporates. The tax gap in South Africa, we estimate, could well be with between 100 to 200 billion, which is roughly between 10 to almost 20% of what we collect. And it's probably more, but I'm simply mentioning that. And that money essentially is the money which is required in order for us to use the first line of our constitution to heal the wounds of the past. So that's critical in the first place. And that's why I think what we have to promote is we're all in this together, and you must pay your fair share. And your fair share is a significant share if, for example, you sit in the lap of luxury. The next point I want to make is you asked me about the question of legitimacy of the system, and it's a terribly important question. So I have three separate responses, perhaps two domestic and one international. The domestic ones are that government is required to essentially spend the money that it raises from taxpayers for that which it promised to do. And let us be quite blunt. I know we're not all South African here, but it would be absolutely ridiculous to gloss over the widespread, endemic, and egregious levels of corruption in South Africa, where taxpayers' money on a daily basis literally is thrown down the toilet, or put it more bluntly, basically finds itself in the bank accounts of rent seekers. And it is no coincidence that tax buoyancy levels have declined as we've seen increasing publication of that which is corruption. Consistently, in my capacity now, as somebody who essentially is an insider-outsider, I'm confronted with this point about, yes, we'll pay our tax, but there are serious arguments, I think, about ensuring ring fencing of money for infrastructure so that it actually goes to where it should go. So if you don't have a government which shows the level of integrity required, you will not have a legitimacy of the system of collection. Secondly is the other domestic point made by many, which is the manner in which tax evasion is rife. It is absolutely extraordinary, the level to which that occurs in South Africa. You own, and I'm talking about South Africa, but I could talk about other parts of Africa as well, in which I've been engaged, but that's not neither here nor there for the purpose of debate. The fact of the matter is that we have vast swathes of taxpayers at the top end, high net worth individuals who either through simply straight bloody-minded tax evasion, which is not picked up by the revenue service, or by the implementation of offshore entities, do not pay tax at all, or pay very little. And this goes across the board, and it's something which I've been working on with others at the South African Revenue Service in order to curb. We really have a major project in this regard, but I won't detain you with that. And then the third point is the one which is made by Asha, which is absolutely right, and by Justice Ngoepe, which is the question of the offshore problem. And of course, there are two or three major issues here. Firstly, is the widespread nature of it. Secondly, is the sophistication of that which occurs, which developing countries are not able to deal with. We are a pretty sophisticated SARS service. Trust me, our transfer pricing and other simpler and similar units are eviscerated. We don't have, even if we had better laws, we would not be able to implement much of this. Let's not be naive about it. We require, and all sorts of other countries require, not just further information which is manifest, not just rules which are skewed ultimately to the benefit of developed countries and against us, as is the case always with regard to global governments, but there is a capacity problem, and it is exploited. Let me give you a simple example. When as chairperson of the Davis Tax Committee, I was approached by a whole bunch of leading Swiss bankers who told me the following. They said to me, we think there's upwards of $500 billion, if not more, in our accounts, which are illegal. Can you not organize an amnesty so that these people actually can regularize their affairs? Otherwise, we've got to get rid of them. Well, the answer is that we had the amnesty, and of course, nobody came forward. And the answer is that it is arguable that they took their money out of their Swiss bank accounts and put them elsewhere. But unless you've got some leverage, i.e. some link to that particular taxpayer in some matter, it doesn't matter how many exchange of information agreements you have, it's extraordinarily difficult to track that down. And that does, in fact, therefore, all three of those combine to completely eviscerate the legitimacy of the system. So if you want to know what we've got to do, we've got to insist that government actually shows greater probity and integrity with regard to money. We've got to put a hell of a lot more pressure on the tax planning community. And I have very little sympathy with them now. They don't invite me to their conferences because they know what I'm going to say. And I will continue to say it. And my own view is when we get a few of them behind, if not bars, behind disciplinary action, we may stop some of this nonsense because they're absolutely crucial to this. And we've got to be able to essentially capacitate developing countries so that as we change the rules, the developing countries are able to exploit those rules to the benefit of the citizenry of the country and more so. And then one final point, it's very interesting that people have raised the question of the international jurisprudence, which of course is extremely close to my heart, because actually as soon as I finish this call, I'm back to teaching that. And why I say that's interesting is because if you look at the international covenant and social, economic and cultural rights, it seems to me that many countries which might be signatories thereto are breaching their rights, their obligations under those particular treaties, precisely by basically being havens for the kind of tax hoarding that we see, because ultimately it diminishes the other right of other countries to vindicate rights in terms of that. There's a serious line of inquiry we need to take in terms of kind of triangulation between countries and the international covenants to see how we can press advantages in that regard. That, of course, is another topic, and I'll leave it for the moment.
Thank you very much, Judge Davis. Again, I think you reinforced the importance of the capacity of states. You know, it doesn't matter if we have information, we have rules, it's around the capacity. And I appreciate in particular your point around accountability routes through international human rights obligations and the treaties that states ratify. Judge Ngoepe, over to you, please, for your reflections on those questions and issues raised, please.
Thank you very much. Unlike my colleague, Judge Davis, I'm not adverse to the concept of an investor. I saw that remark and I was fascinated by it. Well, the important thing is really what that investor expects out of what they put in. If the expectation is something selfish, something that would not benefit society broadly, then I would have a problem. Why I like the concept of an investor is that when you are an investor, you become actively interested in what happens to the money that you put in. One of the things that disappoint me in some countries and communities is that taxpayers do not become sufficiently interested in what happens to the money, the tax that they pay. If that approach of being interested in the outcomes, in the concept of being an investor, if that is going to bring about some tax activism, as it were, to hold the executive accountable, like you hold directors and others in the company accountable. If that concept is extended and used in that way, I have no problem with it. You know, many years ago, when I was much younger than I was in a taxi in Canada. I don't know how it came about. We talked about the issue of paying tax with the driver. And he said to me, I don't mind paying tax here because I know when I'm old, they are going to look after me. I'm going to find a hospital where they'll treat me. And he went on about that. And that in other words, the expectation that people have out of putting in the money is very important. And if that participant means it in that context, I have no problem with it, if it means that. So as I said, I have no problem with it because it will help us hold the executive, the tax administrators accountable like we hold people who run companies. Now, we spoke about the issue of confidence. You know, it's very important to restore confidence. And one way of doing it, there are many ways, but one way of doing it would be, as I said earlier on, to make sure that tax, one, is collected fairly without discrimination. And very importantly also that it is being used in a manner that people will see tangible results to the benefit of poor people. The whole idea about collecting tax is for communal benefit, not for the benefit of individuals. And that the concept of communal benefit cannot be divorced to the issue of economic development and eventually the realization of people's basic human rights. That's what it's all about. And if it goes that direction, I've no doubt in my mind that people will have a lot of confidence in the system. If you link the two, fair collection and legitimate, transparent, proper, prudent use of tax, you are bound to get some positive response from the public. You are bound to get some measure of tax compliance, at least from reasonable people. Well, what happens? You wonder what happens if that confidence is not there, it disappears, it dissipates. Then you're going to have a problem in collecting your tax. I'm going to stop here because I suspect Tricia and Asha might want to add a little bit more. Thank you.
Thank you so much, Judge Ngoepe. So let's immediately ask Tricia then to add to this debate. We look forward. Thanks.
Thank you. No, I've enjoyed all of the interaction here. I do a couple of things. I think people the public has to get more serious. You know, there is a lot of, you know, we have these leaks, we have the ProPublica analysis of taxpayer information, and everybody gets up in arms, but people have to be willing to do the work of figuring out how to actually address this. And so, for example, there were splashy headlines about the fact that billionaires don't pay taxes, but are people really willing to go into the tax system and change the realization requirement? And maybe you can do it with a threshold, and maybe you can do it with respect to publicly traded stock, but that conversation is a hard one, and people have to be serious about it. Again, I'll come back to the leaks. They are not a substitute for capacity development. They are both under and over inclusive, right? There are people who there are many reasons to set up a company. You can set up an offshore company and pay your taxes. Having spent 10 years in Miami and knowing that many rich families set up kidnapping trusts, and having had some of my students have family members who have been kidnapped, I understand why confidentiality and privacy is so important to many of them. And again, that's a symptom of a deeper problem of inequality and lack of development. And so, none of these are easy questions, and none of the answers are going to come easily. And finally, I do want to, the Secretary General is very interested in wealth and solidarity taxes, but again, you have to make sure, as I struggle with them, and I look forward to what Professor Ngoepe is going to say in the next panel. Do you need a new separate tax system, or do you just need to reform your income tax system? But fundamentally, how do you tax the rich in each society without encouraging a brain drain and having them move somewhere else where they will not be taxed at the same rate? And so this is just a plea to dig into some of these very difficult questions and treat them very seriously.
Yeah.
Thank you so much, Professor Brown. And Asha, maybe suggestions, an approach towards answering some of those difficult questions, or are there any other comments you would like to make at this stage? Thanks.
So I would like to make just two comments. One, to actually might be surprising to you, Professor Brown, but I was in Zimbabwe 2 years ago. Well, I'm not sure how long ago, but it was before COVID. So it could have been, in any event, I was in Zimbabwe, and I was with a group of lawyers there, but there was actually a young NGO employee who was just freaked out at that time because her salary, she didn't know what was going to happen with her salary, simply because the government had changed some sort of fiscal policy, and she just didn't know what was going to happen. And she, in that moment, wished that she, like some of her other colleagues, that she had actually followed this trend of having an offshore account, So these offshore accounts, in South Africa, it would be offshore to Zimbabwe. Having an offshore account in and of itself is not it doesn't necessarily have to be a bad thing. But in any event, I'll leave that aside for now. What I would, my one suggestion, I have many, but I'm just going to focus on one based in human rights. That arises from Judge Dennis Davis' point around the International Covenant and social, economic, and cultural rights. The thing about this issue is that unless there's global, a global effort that, with a whole range of countries working together, it simply won't work. If for as long as there's one secrecy jurisdiction in the world, we will have trouble. And so what you find, for example, just in the US, when there was a whole lot of heat on Delaware, and for a long time, there was a whole lot of heat on the state of Delaware. Now the heat has moved to South Dakota,
Yeah.
you know, and South Dakota will experience the heat and it will eventually move to another state in the US, right? That's just the US as a country. But in Africa, for example, there's been a substantial amount of heat applied to Mauritius and Seychelles, for example. But you now have the seeds of an international financial center in Nairobi. The mayor of the City of London initiated the establishment of Mauritius, the tax haven of Mauritius, and then had interesting discussions with the city of Nairobi. And now the city of Nairobi is becoming an international financial center. So it's just moving from one to the other. And what I'm going to propose as a suggestion, it might be, again, me playing around with unicorns, but we have the UN guiding principles on human rights, the UN guiding principles on business and human rights. And one of the tools in those guiding principles are national action plans. The other national action plans, and these national action plans are basically strategic documents that, a plan that the government now agrees to take and implement to achieve particular strategic objectives relating to implementation of human rights. The only two African countries that have put anything like that together. So I was saying that the only two African countries that have produced national action plans are Kenya and Uganda. And they have included certain aspects relating to illicit financial flows and tax havens. But in terms of their action plans, so they've talked about the problem and everything, but in terms of what they're actually going to do, Kenya was the one that said it's going to review its bilateral investment treaties and tax agreements to ensure that its vulnerability to illicit financial flows or tax leakages are addressed, right? In terms of countries of the North, the only country that actually put something down on paper is Sweden. But if there's advocacy around, at the UN level, around the UN guiding principles and the national action plans, if there's advocacy to ensure that every country in their national action plan has incorporated in it, how it is going to review its own policies and laws. And by policies and laws here, I'm not just talking about tax, I'm talking about tax laws, banking laws, company laws, trust laws, and all those different components that to review, and then the investment agreements and treaties, the tax treaties, to review all of them to ensure that the leakages are addressed. It's a pie in the sky, it feels, but the thing about it is if there's a human rights push towards it, if there's the argument that you actually have a human rights obligation to do this, then it changes the discussion. It's no longer just about political will and engaging with the General Assembly and all of that. It is coming from UN human rights bodies. In the African Commission, in the African context as well, the debate at the AUC and the debate on the Economic Commission for Africa continues. But if the human rights mechanisms are also saying that this is not just about, whether you have the political will, you actually have a human rights obligation to do this. It changes the impact and hopefully the outcome.
Thank you very much, Asha. We wish we could go around for another tour, these ideas, these suggestions. And for myself, I'm not a tax expert. I learned a lot, and I'm sure it's true even of those people who are experts in the field. Everyone got food for thought, questions were posed, and I'm sure certain provocations made and perhaps certain questions answered. So thank you very much to our four panelists. It was a very, very good discussion. I think that covered a wide terrain, and I honestly feel it's a good first panel that sets the tone and sets certain parameters for the discussions that follow. So I will, with this, then once again thank Professor Brown, Justice Davis, Justice Ngoepe, and Asha Ramgobin, and hand back to Nina for perhaps just some housekeeping arrangements. Thank you so much.
Thank you, Frans.
Thank you very much. Thanks for the invitation. And we're ahead of time. We started well before time.
We could go.
How often does that happen?
You're impressed by that, Bernard.
Yeah, absolutely.
We certainly had this has been a wonderful panel, and I want to thank you all for doing it. And I agree with Frans, and Frans, you've done a great job as a moderator. And I agree with, I agree with you that this has set the tone for the rest of the conference to really frame what we're talking about as we go to the other panels, to just continue to think about taxpayer rights as human rights and all that that entails.